Welcome to India Today's SoSouth. I am Mahesh Chitnis. In a temporary relief to Deputy CM DK Shivakumar, the Karnataka High Court on Thursday dismissed petitions challenging the Cabinet's decision to withdraw the permission given to CBI to prosecute Shivakumar in the disproportionate assets case. The Karnataka High Court, in its order, said that the two petitions, one filed by the CBI and another by the BJP MLA Basanagouda Patil, Yatnal, are not maintainable and was dismissed. On November 28, 2023, the cabinet had withdrawn the consent to probe the alleged illegal assets of Shivakumar. After that, the two petitions were filed against the cabinet decision. To break down the court order and to understand what does it mean to DK Shivakumar, I am joined in by Supreme Court Advocate Mr. Sanket Enegi. Thank you very much, sir, for speaking with me. Sir, the High Court has dismissed the petition challenging cabinet's decision. What are the observations of the court, and if you can tell us more on the grounds on which the petitions were dismissed today?
First opinion of the court is that it's a matter pertaining to the Delhi Police Establishment Act, under which the CBI has been constituted, which is seeking the permission to investigate. Where the sanction to prosecute has been sought by an agency of the central government to the state government, and the state government has withdrawn that sanction, it is a matter between the central government and the state government, or the central government's instrumentality and the state government. So the court is of the opinion that these are the matter, when it's a matter between central government and the state government, directly or indirectly involved, as in the present case, these are the matters to be adjudicated only by the Supreme Court. And the court is prima facie of the opinion that whether the validity of the FIR, the sanction, to withdraw the sanction, or to grant or not to grant the sanction, these are the questions which are leading to the difference of opinion between the central and the state government as regards the interpretation of a statute. So the court is primarily of the opinion that these are the matters only to be adjudicated by the Supreme Court, which has got a special power under the Constitution in relation to the matters between the state and the central.
Sir, did the Karnataka High Court in its order mention anything on whether the cabinet decision to withdraw consent for prosecution, is it legal or not? Did they touch on it, or just they dismiss the case based on the merits of the petitions?
If you can recollect the origin of this case, initially it was filed by Mr. DK Shivakumar on the ground that there has been no sanction or no application of mine for this sanction by the governor's office or by the chief minister then. That is one of the aspects. So the legality of this sanction was the subject matter in a petition filed by Mr. DK Shivakumar in a 482.
True.
And the court refused to grant him the relief, and against which he had preferred a writ appeal before the court. The matter went up to the Supreme Court, probably you may be aware of. And the Supreme Court is vacated in interim order, and ultimately the matter stood closed by the singular and single judge of the High Court, and 482 petition seeking a under 482 for quashing of the proceedings was dismissed by Justice Natarajan. So that in the case, it was challenged before the division bench as regards the legality and correctness of the sanction. That itself was the subject matter before the division bench. The state government and the cabinet took a decision to withdraw the consent for its illegality or not being in terms of what is required under law. So the cabinet was prima facie of the opinion that the sanction granted by earlier government was without following the procedure contemplated. And therefore, the sanction was bad in law or void, in fact. And that's how they withdrew the consent. And they had relegated the matter to some other agency for investigation. It is not a case that they refused to entrust the matter for investigation or refused to go for investigation, but they changed the Lokayukta. So they just changed the hand from one authority to another authority. So that being the case, the matter stood, when it stood before the division bench for consideration, and the sanction was also withdrawn. There was nothing for the CBI to prosecute further in the matter, and there was nothing surviving in the matter to prosecute or continue further in the case. So a memo was presented before the court stating the state of affairs, and the permission was sought to withdraw the writ appeal, which was objected to by the CBI, in fact, saying that it is not permissible. And subsequently, the matter was challenged, and the refusal of a sanction or withdrawal of the sanction by the state government was also challenged by the CBI, being aggrieved by the order of the government withdrawing it. And Mr. Yatnal, Basanagouda Patil Yatnal, who is also one of the member of the Legislative Assembly from opposition party, that too, from the BJP, also knocked the doors of the court on the ground that this sanction withdrawal itself is an extraneous consideration or malafide exercise or abuse of power. Those two matters were connected to and heard together by the bench headed by Justice Homshekar, and was primarily of the opinion that these are the matters to be adjudicated by the Supreme Court.
So also, if we speak about the hearings, the court order today, there were some of the observations made by the court, and in which they said it's best that the state and the CBI matter must be heard. So if you can just point out some of the observations, why did the High Court find that it is best for the Supreme Court to hear the matter than it decide in the Karnataka High Court?
In my personal opinion, primarily, that what was the subject matter before the court under challenge was the legality and correctness of the order withdrawing the sanction. That precisely was the matter. If the government has considered all the pros and cons and followed the legal principles, then the question would go back to relate back to the earlier sanction to say as to whether earlier the procedure was followed appropriately by the previous government. If the previous sanction was valid, all the procedures were contemplated under law have been followed, then there is no question of again reopening that sanction which has been granted and to withdraw that. That could be one of the questions which was addressable to the court. The court, in my opinion, did not go to the merits of the matter or to the legality and correctness of the previous sanction, and also the subsequent order which withdrew that sanction. So clearly, you can withdraw the consent only when the consent has been granted, and the consent has been withdrawn on the ground that the previous sanction or previous grant of sanction was not valid. So both have to be considered by the court, which, in my opinion, ought to have been done, but has not been done in the case. That exercise has been somehow ruled out on account of the legality and correctness of some other aspect of the matter, and pertaining to more so the constitutional provisions interpretation, which was, in my opinion, was not the matter before the court.
So the High Court also said the petitions are not maintainable, both from the CBI as well as from the petition filed by Basanagouda Patil Yatnal. So as you just mentioned, the High Court concentrated morely on the maintainability of the merit of the petitions filed, and did not go into much of the details of the the validity of the cabinet decision or the previous government decision to prosecute DK Shivakumar.
So, in fact, in my opinion, there was no question which was pending consideration before the court regarding the interpretation of the constitutional provisions. Even though it is the opinion of two judges of the High Court, it is considered as the judgment of the High Court. We cannot rule it out as to accept it legally correct or not. Ultimately, it rests with the Supreme Court to answer finally. But now the court has, in my opinion, considered the aspect other than the legality and correctness of the sanction, which was earlier granted, and the legality and correctness of the order of withdrawal of the sanction. Except other than that, everything has been considered. In my opinion, it should have been. But on the merits of the matter, on the technicality or the jurisdictional standpoint, the court might have refused to entertain the matter, and thereby it has gone to dismiss it at the threshold itself without touching the merits of the matter. That's quite important.
Okay. So also, what next in the case of Basanagouda Patil Yatnal has already issued a statement saying that he will be approaching the Supreme Court, and the CBI also most likely will be challenging the High Court order in the apex court. So there are also some similar cases pending before the Supreme Court. One related to West Bengal and one related to the Supreme Court. So now, what next in the legally in the Supreme Court? From what level the Supreme Court will be hearing the matter?
Insofar as other states are concerned, where there is a difference between the central government and state government. I'm not going by the party. Where there is a difference, some state governments have withdrew the permission which was granted to the Delhi police. In such circumstances, the CBI will not have any jurisdiction without the consent and concurrence of the state government to investigate any matter in that particular state. That's not the case with Karnataka, in fact, so far. In West Bengal, it had happened, and in Rajasthan, you might recollect that it has happened during the previous government. And likewise, in Tamil Nadu, it has. Likewise, there are so many states wherein the state government has withdrawn the consent or approval granted to the central government, that's the CBI more particularly, to investigate another Delhi Police Establishment Act. Unless it is through the order of the court, they will not allow it. And that's not the case in the state of Karnataka. And that being one of the pertinent points, even today in Karnataka, having granted the permission to the CBI and approved the CBI jurisdiction to investigate in the state of Karnataka, the CBI would continue to contend that it has got jurisdiction. So they're quite right so, in their opinion. They have the jurisdiction because it is still continuing with them.
So if you could just recall that CBI in the earlier hearing had said that majority of the investigation is complete, and that's why they should be allowed to continue the investigation instead of giving to some other agencies, like the currently it has been given to Lokayuktha. So what, according to is there any precedence of previous such cases where the apex court or some constitutional courts have given some orders? So what is there any precedence for such cases?
There are several cases wherein the Supreme Court and the High Courts have held that the stage of investigation is of no relevance when the sanction is tainted with illegality or is without jurisdiction. So just because an investigation has begun or has been concluded, it is not coming in the way of testing the legality and correctness of the sanction. If the sanction, that is the originating point, itself is tainted with illegality or is without jurisdiction, everything goes automatically. That's how the courts have interpreted. And the next aspect would be, there are certain instances where the investigations have begun, charge sheet has also been laid, trial also had begun, and at that point of time, sometimes the courts, the constitutional courts more so have interpreted there has been no sanction and exercise the power under 226 right with 482 and quash the proceedings for want of sanction. And there are even the cases wherein the Sessions Court or the Special Court itself, which is conducting the trial under a special act that's called as Delhi Police Establishment Act, and as which has read with the Prevention of Corruption Act, which requires a sanction under 17A, having found that there has been no sanction, they might, well, there are cases wherein they have discharged the accused as well. So, filing of a charge sheet or completion of an investigation is of no consequence or relevance insofar as the case where the sanction itself is the question being adjudicated by the courts.
So, the main point goes back to how the previous government, gave the sanction and the legality.
That's the root of the matter.
So now that will be the biggest question. Even if the matter goes to Supreme Court, that will be first tested before the deciding the maintainability of the petitions by the CBI or the somebody else. That's right, sir?
Very, very true. That goes to the root of the matter. Foundation, if goes, everything collapses. As simple as that.
So true. Thank you very much, sir, for joining us and speaking on this and breaking down on this, complicated cases related to DK Shivakumar. Thank you very much, sir, for joining us. Keep watching India Today SoSouth for more news and